Looking for my stop record button. Start. All right, welcome everybody to Law at the Library, which is a partnership between the Chicago Bar Association, the Evanston Public Library, and the Chicago Public Library. My name is Lorena Neal. My pronouns are she, her, and I'm the legal literacy librarian at the Evanston Public Library. We're delighted to have everyone here tonight for this presentation on guardianship and powers of attorney. I'm going to tell you a little bit about the format for this evening, and then we'll get started. I'm going to introduce our speaker, and she will then give the presentation, followed by a question and answer period. If you have any questions for our speaker, please type them into the Q&A window, which you will find near the bottom of your screen. You can also use the chat feature to ask your questions if that's easier. I will collect your questions as they come up and give our presenter the opportunity to answer them at the end. So feel free to add your questions whenever you think of them. If you have any technical issues or questions, feel free to direct those to me in the chat as well. This is going to be our last Law at the Library session for the summer. We will return in September with a brand new season, so be on the lookout for that. In the meantime, you can always see videos of previous presentations on the Evanston Public Library's YouTube page. I'll post a link to our playlist in the chat in case you're interested in that. And we do also have a list of general free and low-cost legal resources on EPL's website, and I will link that in the chat as well. Our speaker tonight is Christina Puleo. She's a senior associate attorney at Peck Ritchie LLC, where her practice areas include trust and probate litigation, guardianship litigation and administration, and estate administration, will contests, fiduciary defense litigation, and elder law. Prior to joining Peck Ritchie, Christina was an attorney for the Cook County Public Guardian in the Adult Guardianship Division, and she has been recognized as a leading lawyer by Law Bulletin Media's Leading Lawyers Network 2025. We're thrilled to have you here tonight, Ms. Puleo, and I will turn things over to you right now.
All right, awesome. I'm going to try to share my screen so we can kind of get started. Okay. Let me know. Can everybody, wait, hold on. Share. There we go. Can you guys see the screen?
Yes.
Okay, perfect. And you see me, a picture of me? Okay, perfect. So yeah, so we're going to talk about guardianship and powers of attorney in this webinar. You can see my information there with Peck Ritchie. We have a couple of offices. Our main office is in Chicago, but yeah, we do a lot of guardianships and we do a lot of estate planning. So yeah, let's get into it. See, there we go. Okay. Yeah, I guess if you have CEUs, make sure you sign in and do all the things you need to do to make sure you get your certificate. Yeah, so I'm sure you guys probably got whatever you needed beforehand, so you should be able to kind of do that. So, getting into guardianship, why is guardianship necessary? There's a couple of reasons guardianship could be necessary. It could be, you didn't set up, powers of attorney or the proper estate planning documents, and, now you find yourself, either because of illness or injury, you can no longer make decisions for yourself. So, you need somebody to make decisions for you. And the way you do that legally is through guardianship. So we have something here, POA abuse, powers of attorney. If somebody is abusing those powers of attorney, you may find yourself in guardianship court. Undue influence, that unfortunately happens a lot. Mom, dad are getting confused and somebody goes in there and starts trying to take advantage of them to do things they shouldn't be doing. And, other siblings find out, family members find out, friends find out, and, a guardianship, petition can be filed. Breach of fiduciary duty. Let's say somebody is acting as power of attorney, but they're doing bad things as power of attorney. They can lose essentially, or, they can be removed as power of attorney and then a guardian would be needed. Financial exploitation, that is happening more and more. I think it was a thing in the past, but I feel like these scammers are getting really good with AI. So, we just been seeing that a little bit more lately. So that's exactly what it sounds like. Financial exploitation. Somebody's taking advantage of a person who is, unfortunately either, has dementia or is confused or, might have a mental illness or might just be depressed and lonely. So, financial exploitation could end you up in guardianship court. And then a disabled person, right? That was essentially, somebody who is in need of a, person to make decisions for them and they can no longer make decisions for themselves. So those are essentially a lot of, there are other reasons for guardianship, but those are the main ones as to why guardianship can be necessary. So autonomy versus protection. So this is there's essentially a fine line. Sometimes you may not agree with what decisions somebody is doing. Maybe somebody wants to give money to one of their daughters or something, and there's nothing completely wrong. Maybe they want to give $20,000 for them, for a loan on the house, or maybe they want to pay $20,000 for a wedding. It's if the person is able to make decisions, like if they are, if a doctor would not say that they are, unable to make decisions or partially unable to make decisions, they can do it. They can do whatever they want with their money, as long as they're, there's no cognitive issues, there's no mental illness. There's, one of the things is, if somebody is a drug addict or things like that, they potentially could end up in guardianship. But as long as somebody doesn't have any issues with those, they can make their own choices. So there's like a balance, and the court recognizes that too, in guardianship. There's a balance between, how much, how much does this person need a guardian? Maybe they just need a limited guardian. Maybe they need a full guardian, or maybe they don't need a guardian at all. So it really, we'll get more into it, but we'll talk about physician's report, and how doctors kind of come involved with that. But if somebody is able to make their own decisions, then yeah, those are their decisions to make, even if it's bad decisions, or you would think it's a bad decision. But if that's what they want to do, that's what they want to do. So, it's kind of something that you would just have to watch out for and kind of balance that out. Okay, when advanced directives are not in place or fail. So advanced directives generally are, powers of attorney. There's two types in Illinois: power of attorney for property, power of attorney for healthcare. You would need both of those. And then, I know hospitals have like the DNRs, and they'll have like their own powers of attorney of healthcare too. Or, medical, I've seen it from like the medical institutions, they'll have their own power of attorney healthcare form or medical surrogate. But generally for, advanced directives, if they're in place, then that power of attorney would be making decisions based upon what the power of attorney says. And I believe we'll get more into powers of attorney, but, just make sure you read the document and see what it actually says, before, kind of going through with that document. But if they're not in place, guardianship is 100% needed if that person is unable to make decisions. Generally, if that person is in a hospital setting or nursing facility setting and they're unable to make decisions, and there's no advanced directives or nobody can find advanced directives, it would appear that, guardianship court would be where you're heading. That person could have like a home that would need to be tended to, would have assets potentially they would need to tend to, or they just need somebody to help, figure out, Medicaid or, some type of insurance or, kind of just to help them with life decisions. So, that guardianship would be needed. When advanced directives fail, that's generally when either the, power of attorney is potentially, not doing what they're supposed to be doing. Maybe they're unwilling to act. Maybe somebody is named in that power of attorney and they're unwilling to act, so it fails. There's also the possibility of, if somebody was dying or somebody is, incapacitated themselves and they're named in the power of attorney, that would also make it fail. So there's types, there are ways where the power of attorney could fail, and then unfortunately you would be ending up in guardianship court. So just something to look at. And sometimes those powers of attorney like would say I've seen them sometimes. The power of attorney will say, like, when I become incapacitated, then this power of attorney is no longer good. And for me, that really just defeats the purpose of a power of attorney. But sometimes it's on there. So just make sure you read that document. Okay, if a person is capable of understanding the the available options and deciding what he or she wants, guardianship is not appropriate, even if the chosen course of action may be considered contrary to the person's own best interests. So that again is that autonomy. If that person is able to make their own decisions, a doctor would not say like this person needs a guardian or this person needs a limited guardian. They can make their decisions. They're able to make bad decisions. They can, they want to move to, I don't know, some place in Europe or something that's totally out of the ordinary, but that's what they want to do. It's their choice. Okay, powers of attorney. Powers of attorney are a legal document granting authority to another whom you trust to act for you in certain circumstances, your legal clone. So so the power of attorney is an agent for you, and you are what's called the principal. So when you make a power of attorney, you're essentially saying that you want this person to act as an agent for you to essentially act in your best interests. And they have, I know powers of attorney of property have a fiduciary duty, and you might have heard that before, fiduciary duty, but that's essentially, they're legally required to work in your best interests. Okay, so power of attorney for healthcare, and those of you in the medical realm, you've probably seen a bunch of these. So medical or power of attorney for healthcare, essentially that agent will be making decisions for you, in terms of, medical decisions if you are incapacitated. If you are unable to make decisions, again, because of illness or injury, something happens to you, you can no longer make decisions. So this power of attorney of healthcare would be making decisions for you. A lot of times those powers of attorney, you want to make sure you have some type of language on there to help your agent make the decisions you would want. Generally, sometimes the quality of my life is more important, or staying alive is the most important thing to me. Usually, you would find that language on there just to kind of give your agent guidance as to what you would have wanted in certain circumstances. And also in terms of mental capacity, you can revoke it at any time. So sometimes the powers, so this is in the statute in Illinois. It's somewhat new. Anybody can revoke a power of attorney. It doesn't matter how demented you are, how mentally ill you are. Anyone can revoke it. And once it's revoked, you might probably will end up in guardianship court. Sometimes on the powers of attorney, we have a little section on there that says, delay 30 days. And it's just, maybe somebody's having a psychotic break or something's going on where they want to revoke it. But then, a few days later, maybe they'll be like, no, that's completely fine. No, I want to keep my power of attorney. So, sometimes on that power of attorney, it delays revocation. So again, just make sure you read those documents, see what it says. If you don't see it on there and somebody revokes it, yeah, they can revoke it. Yeah, so just be aware of that. And not only does the agent under the healthcare power of attorney make healthcare decisions for you, but they make all the personal decisions. So anything that has to do with clothing, anything that has to do with food, your day to day, they're the ones that kind of sign off on those things. And, placement, they would be the ones that figure that out as well. So that power of attorney would be, kind of handling all those different scenarios. So power of attorney for property. So again, this is a person that you name to be an agent to essentially act for you when you, again, are no longer able to make decisions. And the power of attorney of property is going to be handling all the finances. So you really need to give the power of attorney to somebody that you trust. This is probably one of the more documents that is fought over, because if, somebody is, saying that they're not doing a good job, and they go into guardianship court. The power of attorney for property, a request can be made for an accounting. So an accounting, if you're acting as power of attorney for property, just be aware that you should be keeping all your receipts. You should be, making sure everything is, separate. You're not commingling funds. That's a huge thing too. So, a lot of times I know parents will put their kids on as joint owners on a bank account, and, it's maybe just a bank account, it's an account of convenience is what we call it. But just be, try to make sure everything is separated, that you're not actually using it as a joint account if you're acting as power of attorney for property, that you kind of separate everything there. So yeah, power of attorney for property, again, read the document. It says what powers they have as power of attorney for property. Generally, they are able to manage, the whole estate and all of the assets. They can change or they can buy and sell property, things like that. They can do those types of things. But sometimes the power of attorney for property will not allow real estate transactions, but you just have to read that document and see what it says. Sometimes there's limitations, sometimes there's not. Um, so it really depends. And then when you create your own power of attorney for property, you can put those limitations, or, if you just want, okay, I want them to handle everything, you would just, put no limitations then, they can handle anything. Sometimes, we'll get questions as to estate planning, like, can my power of attorney for property, can they change my estate plan? No, they can maintain your estate plan. They cannot change it without going through court. Because then power of attorney for property, if you start to try to change things for principal, when the principal is incapacitated, you're going to end up in guardianship court, and it's not going to look good for you. So, just make sure if, that your principal really wants to change their estate plan, or anything comes up like that, you would have to head to guardianship court, and there is a process there for estate planning. Um, so yeah, so just be careful if you are acting as a power of attorney for property. Again, no commingling, keep all receipts. You could be asked for an accounting at some point. And then, yeah, just, try to, I always advise people just, if there's other family members, try to be, you know, somewhat open as to kind of what's going on. You don't have to be, but, a lot of times people are just very suspicious of one another, sometimes family. So, just be mindful of that. Okay. Okay, guardianship is a default estate plan for disability purposes in Illinois. So what that means, if you don't have powers of attorney done, if you don't have estate planning done, um, you know, you will end up in guardianship court if you find yourself in a position where you are no longer able to make decisions for yourself. If a doctor comes back and says, this person is totally incapable of making personal and financial decisions, or this person is partially incapable of making personal and financial decisions, you more than likely will end up in guardianship court. So, so these are kind of the questions you ask yourself. Can that person make decisions for themselves? Does this person have a proper plan in place? Is the plan appropriate or valid? Are the agents willing to act? So those are all the things you kind of need to go through to see, whether or not, guardianship is there. So yeah, yeah. I mean, so if somebody's in the medical field and you see somebody that can make decisions, do they have these documents in place? If so, reach out to that agent who's named, and hopefully they name more than one person. So if they name more than one person and that person is, not willing to act, make sure maybe you've called them a few times, or, called them multiple times and they haven't picked up. Maybe you've tried to email them, maybe you've tried every single way and they're not picking up, they're not doing anything. You can go to that next person on that line, see if they have any information of, person number one. If not, then you can start talking to them, see if they're willing to act, and kind of just go through that list. Okay. And again, if you don't plan, you are going to end up in guardianship court. If somebody, a guardian is appointed by the court to serve as a representative, so yeah, you would have to file a petition with the guardianship court. If you are appointed as a guardian, generally you would have to report to the court. If you were, in guardianship, there's two types of guardians. There's guardian of the person and guardian of the estate, just like powers of attorney, power of attorney of healthcare, power of attorney of property. So, guardianship court is also broken into those two sections as well. A family member can serve as guardian, a friend can serve as guardian. You just really need to make sure you give notice to the family members. In Illinois, you need to give notice to, it's in the statute, you have to give notice to parents, siblings, children, And if you can't give that notice to any of those people, you don't know anybody, at least some sort of significant contact, and it's in the petition. You would just kind of name that. You would just make sure you give notice to those people. Because if you don't give notice to people, and let's say a guardian is appointed, and let's say, I don't know, 2 years goes by, and somebody shows up and says, I was never given notice. Essentially, you've just destroyed the whole guardianship, and it needs to start at, zero. So just make sure you give notice to everyone. A court-appointed guardian may make decisions consistent with the procedures and requirements of the Act without judicial involvement. So yeah, it depends on. So guardianship court, yes, you would be the court-appointed guardian. You can make some decisions without judicial involvement, obviously, like if this person needs, I don't know, more depends or something, you can make those decisions. But in terms of guardianship, we generally want to have like a budget involved. We want to have something to show the court this is how we're taking care of the person. This is assuming that there's a guardian of the person and guardian of the estate. If it's just guardian of the person, generally the courts just want what's called an annual report. And that annual report would be given to the court, obviously annually. And it's just telling everybody or just telling the court how that person is doing. And then I do want to go back to that number two, where an agency could be potentially become guardian. So that is the case. That could happen, that an agency could be appointed as a guardian. If family members are fighting each other, generally the court would want a neutral third party involved. Or if there's no family around, it could be an agency, and it could be a private agency. It could be the Office of the State Guardian, or it could be the Office of the Public Guardian. I'm not 100% sure if we go through Office of State Guardian, Office of Public Guardian, but in these slides, but Office of State Guardian, you would essentially make a referral to them if that person is living in like a facility and there's nobody to make decisions for them and they have absolutely no assets, or really nothing other than maybe Social Security. You would call them, make a referral to them. Office of the Public Guardian, at least in Cook County, pretty sure this is everywhere else in Illinois as well. It's 25,000 is the asset limit that they need. So they need at least, I should say that, at least 25,000 in assets for them in order to be able to act. And some counties I've noticed are a little bit different in terms of what counts as an asset. Sometimes they won't, like maybe somebody only has a house. Sometimes they won't act when it's just a house, but it kind of really just depends on that Office of Public Guardian and kind of what they do in their county. And then that last little bubble there, a diagnosis of Alzheimer's disease or dementia alone is not an indication of incompetence. So I think, if you're a medical professional, you probably know, or assume you know, that dementia and Alzheimer's disease, there's different stages. So, somebody just got a diagnosis, that doesn't necessarily mean they can't make decisions anymore. And sometimes you'll find that with families, as soon as somebody gets an Alzheimer's disease or a dementia diagnosis, they feel, their sons or daughters might, just try to take over their life. And, that's not, it could not be the case. You would need a doctor's physician to come around and see whether or not, they are still able to make decisions. But, somebody could have dementia for years and still be able to make their own decisions. It kind of just depends on where they are in their disease. Okay, assessment of need for guardianship. So this is the physician's report. So it needs to be a doctor. So the statute is pretty clear on this. It needs to be some sort of doctor. It cannot be a nurse practitioner. It cannot be a physician's assistant. It needs to be a doctor that signs on this document, the physician's report. And so each county has their own form for a physician's report. I haven't found a county yet that doesn't have their own physician's report form. I'm sure there's probably some out there. But they generally have their own form for a physician to fill out. And it's generally, what's the diagnosis? Is this person, how is this diagnosis affecting them? Is this person capable of making decisions? Are they totally capable of making decisions, partially capable of making decisions? what type of guardianship do they need? Do they need a full guardianship? Do they need a partial guardianship? And then what's the best place for them to be? Can they be home with maybe just 8 hours of caregiving, or do they need 24 hours care? Do they need to be in a facility? Depending on how much they're into a diagnosis, it could be that they need to be in a facility. So it kind of just depends. But yeah, so the courts look to this report of physician. You cannot get guardianship without it. And in Cook County and at least in Lake County, DuPage County, McHenry, all the other ones came. They do need a physician's report even for a temporary guardianship. Now, a temporary guardianship is like an emergency guardianship. Let's say something is going on, and this person needs a guardian right now. Something's happening. You would still need that physician's report in order for that temporary guardianship to be given. Now, that's not all the time. There are very rare occasions where the judges will give you a temporary guardianship without a physician's report, just based upon, kind of the allegations and what's going on. Let's say somebody is getting scammed. Let's say, they've mortgaged their house and that's recorder of deed information. And at least in Cook County and some of the other counties, you can look on the recorder of deeds website and see what's going on. And maybe you see they just took out this mortgage and, oh, they just gave all this money to this person and they're trying to take out another mortgage. So then, you would bring that information, you'd bring that documentation to the court and make the request, and maybe it could be on a limited basis for a temporary guardianship. That person could have their accounts frozen or, at least let the temporary guardian get access to all the information to investigate as to what's going on. So at the next court date, they can bring everything and, get that physician's report. And then so going back to that physician's report, if somebody files a petition and they don't have one and they're unable to get one, generally what we would do is we would file a petition for independent medical evaluation. And the statute's pretty clear on that. It's pretty clear that it says that, if somebody petitions for guardianship and, and a report of physician is not made available to the court, the court shall order essentially an independent medical evaluation to be done on the person who's being, and we call them the respondent. So the person who has the filed guardianship, against them. So, generally that report of physician is really important. And if we can get that, it kind of makes everything run a little bit more smooth. Okay, so that's assessment of disability. So what type of disability essentially qualifies for guardianship? So there are 4 types in Illinois. Obviously mental deterioration or physical incapacity is not able to manage his person or estate. So, obviously because of cognitive decline. Some sort of cognitive decline is happening. They're not able to make decisions, so they would potentially qualify for guardianship, again, once once a physician has seen them. Another one is mental illness or developmental disability, unable to manage their person or estate. Developmental disability, we do get a lot of those, people that have, children that have been developmentally disabled, and then, they just need to get a petition filed for the court just for guardian of the person. Maybe that child doesn't have any assets and they just need guardian of the person. I know in Cook County, they used to have the what was it, the guardianship help desk. I knew it went away during COVID, but I think it's back. But they could help you potentially fill out the paperwork needed for guardian of the person if you have a disabled child. But yeah, you definitely would want to get guardianship of the person of that child, just so, there's no issues if there was, anything medically going on with them, that you wouldn't be stopped or anything. Mental illness, is a hard one. Mental illness is it's not impossible to get done. We have gotten, people who have been, mentally ill, have gotten that guardianship. It's just a little bit harder because, if they do start taking their meds and they come back, it's like, okay, well, we no longer need the petition or maybe they just, they just leave and then we can't find them. So, mental illness is one that's a little bit more difficult, but it definitely, we definitely can go to guardianship court and get that one done as well. This one I haven't seen too much. I think maybe like twice, because of gambling, idleness, debauchery, or excessive use of intoxicants or drugs. So spends wastes his estate as to expose himself or his family to want or suffering. So yeah, so this would be the drug abuser. I believe alcoholic was the one that we were able to kind of get done. Is they were drinking like gallons of alcohol. Um, so, they weren't able to really, kind of handle any of their, estate or matters or anything like that. And then, sometimes that, will lead to alcoholics dementia. So, so yes, you can bring a petition for guardianship under that one as well, if somebody has, one of those things going on. And then the last one there is diagnosed with fetal alcohol syndrome or fetal alcohol effects, which, you probably would know about sooner rather than later. But yeah, you can bring a petition under that one as well. So the role of medical professionals. Um, so we trust medical professionals to essentially kind of let attorneys know, let the court know as to, whether or not this person needs guardianship. Do they have the capacity? If they don't, then, what type of guardianship do they need, whether it's limited or whether it's a plenary guardianship. A limited guardianship would be that if that person is partially incapable of making decisions, or, and sometimes it's, partially incapable of making financial decisions, but they're able to make their own personal decisions. So we don't need any type of guardian for the person, but we might need a limited guardian for the estate. So it kind of just depends in what the physician essentially says on that physician's report. So that's why it's so important. And an assessment for the least restrictive options for care and treatment. So that's huge for the court, because they recognize obviously that these are all people that are coming under guardianship. So, they want to give them as much freedom as can be allowed safely. So, if they are able to live at home and there is, caregivers or family that's able, trusted family that's able to look after them, they'll hear it, they'll entertain it, they may try it. So, they really want to try, to really try to find that least restrictive option for the person. So yeah, the courts do care. Okay, so hypothetical. So I'll just read this even though I know or I'll read it out loud even though I know you guys can read. So Bob, a 70-year-old widowed retiree, lives in a large condo on Lakeshore Drive. Bob goes to church every Sunday as well as the senior center twice a week to play chess. He only has one child, Mary, who lives in Florida and visits on major holidays. Lately, Bob has become increasingly forgetful, confused, disoriented, and is hospitalized after slipping on a patch of ice, injuring his hip. While in the hospital, he was diagnosed with dementia. He refuses to move out of his condo, so he hires a caregiver to help him with daily activities such as laundry, cooking, and making sure he was properly dressed, since he occasionally forgot to change his clothes. Bob is incredibly lonely following his injury and diagnosis. He finds consolation and companionship with his young caregiver, Stacy. Stacy is a very attractive divorcee with a child. Stacy doted on Bob from the start. In addition to her duties as his caregiver, she started to pay his bills, accompanying him to church, and go shopping with him. It wasn't long until their relationship took a romantic turn. Stacy and her son immediately moved into Bob's opulent condo. Shortly thereafter, the two made travel plans, and Stacy suggested that Bob buy a new car, preferably a luxury SUV, so that they would have enough room for all their things. Stacy took Bob to the Lexus dealership where he bought a brand new Lexus SUV. He wrote a check for half of it and financed the rest. She suggested that he put her name on the title as well, since she would be driving the SUV during their trip, and Bob agreed. Now that Stacy and her son were living with him, she suggested that Bob should get rid of any other nosy caregivers and housekeepers because she would be the only caregiver he would need. Stacy then also suggested that Bob add her name to his bank accounts so that she could do the grocery shopping and take care of household things. She also suggested that they meet with his stockbroker to make sure she could use those funds to take care of him. In addition, she mentioned that he should call his attorney to discuss revising his will so that she would be taken care of. Bob said, "Anything for you," and gave her the numbers to call and make the appointments. Meanwhile, Bob's daughter Mary began to get concerned. It was increasingly difficult to reach her father. He had always been a very cautious decision maker, and when Mary learned that he moved a woman into his home after only 6 weeks, she became worried. Mary, however, was afraid to say anything because she knew how lonely her father was, and she felt that maybe this was what he really wanted. While in town for Thanksgiving, Mary went to an attorney to see what she can do. She was named her father's power of attorney a few years back. Her lawyer discovers that Bob had not only recently redrafted his will, replacing her with Stacy as beneficiary, and named Stacy his new power of attorney. So this would be a scenario where a temporary guardianship would be needed, or in Mary's case, that's what she would be going for. As I said previously, powers of attorney, you shouldn't be doing estate planning documents. If you notice that somebody is having that undue influence over somebody and they're making decisions, that are not appropriate, um, especially if it's not a family member, in this scenario, it was a caregiver. So that's really going to raise some red flags for the court. It's this new caregiver that's just come around. Now he's changing everything to this caregiver. It's going to make the court worried. So steps for temporary guardianship, right? Obtaining that physician's report. So that would be something that Stacy would be doing, is trying to get that physician's report. And again, each county has kind of like their own form to fill out. Generally, again, I haven't seen a county that doesn't have a form, but yeah, we would need that doctor to sign off on it. Yeah, the doctor would be, deciding whether it's mental deterioration, physical incapacity, mental illness, developmental disability. The judge, again, will not approve its temporary guardian without an accompanying doctor's evaluation. And again, that's usually the case. Sometimes we're able to get them to give us at least a limited temporary guardianship, depending on the allegations and what's going on. So if Stacy had, all the documentation showing that, oh, look, big sums of money were transferred to Stacy's account, and look, he changed all the estate planning documents, and we attach it to the temporary petition, there's a chance the judge would grant a temporary petition without a physician's report. But with that physician's report, it's almost a guarantee. But without it, you can make a strong case and try. But generally, the courts are more comfortable, with that physician's report, and it should be that way because essentially, guardianship is taking away, a person's rights, right? The right to buy what they want, the right to see who they want, the right to live where they want. Guardianship is taking away all of those rights, and the judge recognizes that, and that's why they generally feel more comfortable having some sort of doctor sign off saying that this person needs a guardian in order for them to grant either a temporary or plenary guardianship, just because they realize what guardianship means and what's going on. You may see it as, oh no, this person really needs help. We need to do something. But that again, they're taking away rights. And if it's a temporary guardianship, they're taking away them, temporarily. But if it's a plenary guardianship, essentially they're taking it away until either they pass away or they can be their rights having been reinstated. They can be that could be a petition, brought to the court, depending if they, maybe there's a sickness and they get better. So, there's ways where you can end the guardianship, but it's really, their rights are taken away until further order of court. Okay. So after you receive that physician's report, hopefully, you file your petition for plenary and temporary guardianship simultaneously. So you do need both petitions on file. Generally, you would file that plenary guardianship petition to get a case number. You would file that one first and then file the temporary guardianship. It could happen at the same time, same day, but you would need both of them. And a temporary guardianship petition really should not be filed until a plenary guardianship is filed, because that's in the statute. It's essentially temporary guardianship. You need that plenary guardianship first. And then, yeah, in that temporary guardianship, you have to say why a temporary guardianship is necessary. And this is big language that the judges look for. The explanation should focus on the immediate welfare and protection of the alleged disabled person and or his estate. So that's the exact language that they look for, or the judges, and that's when they make their ruling, they use that language as well. So again, temporary guardianships are like an emergency guardianship. Something is going on where we need a guardianship right now, and we need to explain to the court why it's an emergency. Because essentially, when we bring these temporary guardianships, it's usually like within a day, or sometimes we can get it in a day, but it's usually like within 2 days, 2 or 3 days. So, they happen pretty fast. We try to get on the judge's schedule. Judges, if it's not a real emergency, they will get angry with you that you brought this to them. So, you want to make sure that you have an actual emergency there. And then generally, when a temporary guardianship is filed, 99.99% of the time, you will get a guardian ad litem appointed. And I just leave that, zero point zero 0.01 off there just because, there are, it could be a random case where one isn't appointed, but generally one is appointed. So a guardian ad litem, some of you guys might have heard that term. What that is, it's an attorney, usually an attorney, that works in probate, that is appointed by the court to essentially investigate, what's going on. Is there emergency going on? Does this person need a temporary guardianship? Does this person need a plenary guardianship? Is this person contesting the guardianship? Because that's their right? Because again, guardianship, we're taking away people's rights. So they have a right to contest. They have a right to say, I don't want a guardian. I don't need I don't want a guardian. I don't need a guardian. Maybe the person who's petitioning, they don't like that person. They could say, I don't want that person to be my guardian. So the guardian ad litem is the person that goes out and talks to them to see, do you want this guardianship, and, investigates the situation. So they'll talk to they'll talk to the petitioner, who's ever bringing the petition. They'll usually talk to the attorney who brought the petition. And usually, so in Cook County, the courts will notify the guardian ad litem. In all the other counties, maybe not Lake and DuPage, but I think so too. They, the petitioner, the petitioner's attorney, or the petitioner themselves would, usually the petitioner's attorney. Petitioner's attorney would be the one that notifies that guardian ad litem and lets them know, like, hey, you were appointed to this case and let me talk to you about it. So, yeah, guardian ad litem is super important. If you're ever talking to a guardian ad litem, just realize they are not a guardian. They are just a person that's an attorney that's appointed by the court to investigate things. They are there to make sure that that person is safe, or we need X, Y, and Z for that person to be safe, and they'll report that to the court. So if you're ever talking to the guardian ad litem, pretend you're talking to the judge, because judges, for the most part, take the recommendations of the guardian ad litems like 99% of the time. So guardian ad litems are a big deal in guardianship court. And so just if you're ever talking to one, just pretend you're talking to the judge. Okay, and there he is, guardian ad litem. So, and then, yeah, the eyes and ears of the court. Again, acting kind of like in the stead of the judge. So if the judge was able to, come off the bench and investigate themselves, that's what the guardian ad litem is role. That's what they're doing. And again, typically an attorney, but it's not always the case. Generally in Cook County, DuPage, Lake, McHenry, Kane, all those, you will have an attorney as a guardian ad litem. I think in all the cases, like we've handled some, and I know in like Kankakee County, Peoria County, anytime a guardian ad litem was appointed, it was an attorney, but the statute doesn't require it to be an attorney, but generally that's, the judges maybe just trust an attorney's opinion more, but it's generally an attorney that's appointed as guardian ad litem. But yeah, again, if it's a temporary guardianship, they 100% will. Well, not 100%, I want to say 99% of the time they will appoint a guardian ad litem. And in a plenary guardianship is, when we're trying to go for quote unquote permanent guardianship, or guardianship until further order of court. the guardian ad litem may be appointed on that time, even if there's not, um, even if there's not a temporary guardianship involved, maybe it's just a regular guardianship, a guardian ad litem could be appointed. So you just kind of have to just see if the judge decided that one is needed. So, order appointing a temporary guardian. A temporary guardian only has the powers and duties enumerated in the court order. So yes, so all of the temporary guardianships, and sometimes the temporary orders in different counties don't really have like a section for this. So then we'll just kind of like see Exhibit A as to the powers. But yeah, it's generally the powers and duties will be on usually a separate sheet. The order will say this person's been appointed temporary, and then usually in the separate sheet, it'll say like these are, the duties and powers. So again, like let's say you didn't get a physician's report, but you have, all this documentation that this financial exploitation is happening. You can, it could be a very limited temporary guardianship order where it just says, person is, this petitioner is, the temporary guardian is allowed to investigate accounts, is able to get accounts for banks X, Y, and Z, all statements, from, maybe 2 years of statements. And then, next line, it would be, they have the power to freeze these accounts. So kind of just depends on the situation going on, but it'll enumerate, what those duties are as the temporary guardian. So if you're working with a temporary guardian, you have an order, just make sure you also have the page for the powers and duties. So I know I've mentioned this a few times, plenary guardianship. So plenary guardianship is essentially just, I don't want to say permanent guardianship. It's kind of like permanent guardianship. But permanent, to an extent where you potentially could get rid of the guardianship still. So even if you're appointed as plenary guardian, it's essentially you are guardian until further order of court. What that means, if somebody could be restored, let's say somebody is, maybe that's that mental illness scenario where they needed that guardian maybe for a couple of years, but now they've been pretty stable. You would get a doctor's report that says that this person is stable now, and they can be restored. So steps for plenary guardianship, there is information you need to put in this petition in order for the court to consider it. The relationship, the interest of the petitioner to the respondent. So the respondent would be that person you're trying to get guardianship over. They would need date of birth, place of residence, name, reasons for guardianship, post office address of the respondent's guardian if they have any. And again, that notice is really, really big. You would need the spouse. I forgot about spouse when I was first talking. Parents, spouse, children, and adult brothers and sisters. And then if you don't have those, the nearest adult kindred known to the petitioner. And again, that notice requirement is very, very huge. So make sure you give notice. If you're ever talking to family and they're like, I don't want this brother to know about it, you're gonna have to tell them no, like they need to know about it. Like it would be very bad if they didn't. You can't do it behind their back because the whole guardianship would be gone and the judge would hate you. So just make sure you give notice, or at least, make attempts to give notice if you don't know, brother's address. Whatever attempts you can show to the judge that you try to, get their address, or, maybe they're in the wind and nobody knows where they live now. So just make sure you give notice to people. Very big. Um, if that person's in a facility, let them know, what facility they are, approximate value of the personal and real estate, approximate value of income. If you don't know, and sometimes we don't know, we'll usually put like under investigation. So, we're just trying to figure that out, but this petition need to be filed. And then, you would need the name and post office address, and in case of an individual, the age and the relationship to the respondent and occupation of the proposed guardian. So yes, you would need whoever's petitioning would need to make sure that they have their age and occupation written down and address written down, if they want to be guardian. Um, da-da-da. Okay, yeah. So petitioning for guardianship doesn't mean you're going to get guardianship right away. It doesn't mean you're going to get guardianship right away, but if you do have the petition on file, and let's say you're like, wait, never mind, I want to take it back, you need leave of court in order to withdraw it. So just make sure that, if you're filing for guardianship, that, you're in it for the long haul for the most part. But you do need leave of court to withdraw it. We just had one where we filed for guardianship and then the person found powers of attorney. And so then we had to file a petition that says, Judge, we found, powers of attorney. Please allow us to withdraw this petition. And again, we needed leave of court to actually withdraw that petition and close that estate. Okay, duties of the estate guardian. I know we're running out of time. So duties of the estate guardian are kind of just like that, the duties of the power of attorney for property. They have to manage the estate, all the assets, all the real estate, all of that. Generally, especially for Cook County, Lake and DuPage, any type of contracts that you're entering into, if you have an attorney, just make sure you talk to them about those contracts. If you're trying to sell property, you generally need leave of court to even to even list the property. So you would need to petition the court and ask for permission. You generally need to ask the court for permission all the times for guardianship, for any type of for guardian of the estate. If you want, and then just another thing to be aware of, you would have to do annual accountings to the court. That's pretty big. So, if you spend $50 at Walmart, just make sure you tell the court what you spent $50 for. The court is heavily involved with guardianship. In other parts of Illinois, the courts aren't as involved, but they're still pretty involved. They'll still want the annual accounting. That's in the statute. They must account. So, you must submit that to the court every year. And again, if the court for whatever reason feels like, maybe something's going on here, maybe, we need to I don't know, for whatever reason, red flags were, the judge finds some red flags, they could they could appoint a guardian ad litem, reappoint a guardian ad litem, or they can essentially mandate that you give statements to them. So just make sure, again, you're just being careful if you are acting as guardian of the estate as to, how you're managing those assets. Duties of the guardian of the person, again, kind of the same thing as the power of attorney for healthcare. You're just making sure that everything is, taken care of, health-wise, education, personal, whether or not they need therapy or other professional services or something, you would be the one that's kind of managing all of that. And then what you would be doing is you would be giving annual reports to the court as guardian of the person. So that annual report would essentially just, kind of say, how they're doing to the courts. And those are needed yearly, obviously, annual reports. So you would just, if you don't have an attorney, you would just mail that in. If you have an attorney, you can give it to the attorney to file and send it into the court. Yeah, so, at the guardian, you have a duty to your, to the person you're guardian over, make sure that you are, working in their best interest, make sure you're adhering to state laws, make sure you're following, professional code of ethics. This person needs help, obviously, and, the court is, relying on you to provide them with that help. And then residential placement. Generally the state guardian will not take somebody unless they're actually in a facility. If somebody is living in a facility, when you become guardian, you really can't move them without court permission. Let's say something happens and, it's an emergency, they need to move. Something happens, or maybe they went to the hospital and then they need to go someplace else. You can ask the court to ratify that change in placement. If something happens and, it needed to change rapidly, or maybe their level of care just, drastic change in level of care and they needed to go someplace else, you can ask the court for ratification if an emergency arises, or you can petition the court on an emergency to change the placement. But you generally need, court order to change the placement. Public guardian office, the state guardian, do not need court permission, but regular guardians do, guardian of the person. So don't move them without court order unless it's like an emergency or something's going on. Any questions? And we have like 3 minutes.
All right. Thank you so much, Christina. We do have some questions. I will start going through them now. Just to clarify for everybody watching, we have recorded this. This will be posted on our YouTube page, so you will be able to go back and visit it. I will send out that YouTube link to everyone registered as soon as we do get it posted to our page. It usually takes a couple of days, but that will be available. And then Christine, you said you were gonna share the slides.
Yeah.
Okay.
I can share slides.
So I will send that out in the same email with the link to the recording. We'll have the slides also so that you can go back over some of the things like how incapacity is determined and the legal definitions. So starting out, do you have any idea, Christina, kind of how long the process takes to determine incapacity with a physician?
So it depends on the physician. I mean, sometimes if somebody has a primary care physician, I could stop sharing actually. So if somebody has a primary care physician that they see regularly, that's good. The big thing with reported physicians, it just has to be with when you file that guardianship petition, it has to be within 3 months of that of the doctor seeing that person. So it'll be on that form essentially saying, I evaluated this person on this date. So that date you have 3 months essentially to file your petition. But how you get it, I mean that's sometimes the big question that we even have. Like, when are we getting this report of physician? When is the doctor going to give it back to us? So it really depends on the doctor. Yeah, and the doctor schedule.
Okay. And in terms of the court times, is there like sort of an average length of time for a guardianship case in terms of proceeding through the court?
Oh, okay. So for guardianship proceeding through the court, it depends on the county. So for Cook County, once you file that petition, it's usually a month and a half before you go into court, unless there's again you file for temporary guardianship, you get an emergency, and that's even for DuPage, Kane, or sorry, Lake County. Lake County can sometimes be a little bit more. It's sometimes like 2 months. And DuPage, it's usually about a month and a half. So it kind of just varies, but it's usually about a month and a half before you go into your initial court date.
Okay. And you mentioned something about $25,000 being kind of the threshold. What is that for a public guardian to be appointed? Can you explain that a little bit? Like, is that the amount of
Yeah.
they have to have at least that much, or they have to have below that amount?
Yeah, so for the public guardian, they need to at least have 25,000. So a lot of times, sometimes the only thing they have is their house. And maybe they just get like Social Security or something. So yes, in order for you to make a referral to the Office of the Public Guardian, so whatever county you're living in, you can Google them and then look them up, call them and just let them know, this person is, living here, or maybe they're living in a squalid house, or maybe it's a hoarded house and you're concerned about them. You would make a referral to them, and you might also make a referral to Adult Protective Services because that probably would be a self-neglect case as well. But you would want to refer to both of them. And then the Office of the Public Guardian potentially could take over because that house I mean, generally a house is over $25,000. But that's their threshold, as you need to have at least that amount in order for them to potentially take the case.
Okay. And if they don't have $25,000 and they're in need of help, what happens then?
So then you would go to the Office of the State Guardian. Well, Office of the State Guardian, you can talk to them, but they generally won't take it unless somebody's in a facility. So if somebody is living in a home that is hoarded and they're confused, you would want to get Adult Protective Services involved. Potentially, they'd be able to remove them from the home and into a hospital facility setting. And then you'd want to get the Office of the State Guardian involved. So that probably would be the best path there.
In terms of providing notice, who are you providing notice to, and how long in advance of all this do you have to provide notice?
So notice has to go at least 14 days prior to your first court date. If it's an emergency, you need to it needs to at least be 3 days beforehand. However, the court could waive it with good cause shown. Like, let's say it's a super bad emergency. Unfortunately, we can't give notice to everyone. Something really bad is happening. Sorry, judge. And the judge could waive notice. So, you wouldn't need to do that. But for the actual plenary petition, you do need 14 days before that to give notice. And then there was a list on there. You need to do spouse, parents, siblings, brothers and sisters. Those are the ones you'd give notice to. If maybe they don't have anyone, you need to at least get maybe like a friend, somebody, some sort of next of kin, somebody.
Okay. Someone wants to know where they can find details on how to keep records of the expenses if they're power of attorney for both health and property for their uncle.
Um, so I'm pretty sure a lot of people sometimes use like QuickBooks or I know there's like other software devices like that, but that's generally what they do and kind of just or sometimes they just use an Excel sheet. I've seen people do that as well. They just anything that you spend, you kind of just just mark it down or put it in a file or do something. You just want to make sure you keep your records. That's really what you want to do. Because again, especially if family is suspicious or there's something going on and you're like, I don't know, I feel like this person at some point could cause some problems. You just want to make sure you keep all your records. You could essentially you can Google that. Like you can kind of put it in Google and it'll tell you like the softwares that you can use. In terms of just like specific information. And I'm not really aware of like any sites in particular. But again, you just really want to just make sure and it could just be a bank statement. So like, the bank statement, you're just using this one account for this person. So, just make sure you title it as POA, Mary Joe POA for, this person. So that way you have it all in this bank statement, keep your checks. And that way you can kind of account for anything that's done because that's how sometimes we have to do POA accountings, and that's what I look at is the bank statements and the check images, and I see what we're spending on, and then if it's something, what was this for? Just make sure if it's something a little off, just spent this money for new construction or something.
Mhm. And if there is a power of attorney that's already named, then there's no need for guardianship. Are they mutually exclusive or can there be both?
So if you have a power of attorney, then you don't need a guardianship. If you have power of attorney for healthcare and power of attorney for property, you need both. Then you would not need a guardian. Powers of attorney trump guardianship. So if those are in place, the guardianship court, once those are produced, I'm sure there'll be a little fight about it. But if the court holds that those powers of attorney are valid, let's say somebody, made them like 5 years ago, as opposed to, oh, they made them a month before filing for guardianship. Okay, those are not, no, but like if they're made 5 years ago and the judge is like, these are good, then the judge will dismiss the guardianship and it'll just be running on the powers of attorney.
Okay. If someone doesn't have trustworthy family, can they do a power of attorney with a friend?
Yeah, you can name a friend as a power of attorney. What you probably want to do on that is just, maybe make a little note on that power of attorney. Just, I chose not to name a family member at this time and would like this person to be named. Just so they know that, this person consciously made that decision, and just, wanted that person. But yeah, you can name a friend. You can even name potentially a what's called like a case management company. There are some that will act as guardian of the person. You would just, reach out to them and, see if they'd be willing to act as your power of attorney power of attorney for person.
And then do you need to register a power of attorney with anyone or notify anyone that you have a power of attorney?
No, I mean, if you do have a power of attorney, you don't have to, but what you should do is you should like if you like have a power of attorney for healthcare, you should give it to your physician. If you have a doctor's office that you normally see, you should give it to them because again, in case something happens to you, somebody needs to know what's going on. Give it to who you named as power of attorney so they know, oh, I'm gonna need to act, if something were to happen. So just give notice to the people that are on there. And then again, just give it to, maybe your financial institutions as well, your bank. If you have a power of attorney for property, give it to them just so they have it on file. But it's not required and there is no registration. If somebody has a doctor's report, and the doctor says, this person is unable to make decisions and now, powers of attorney come into play, you don't register it anywhere. The bank, you would just bring it to the bank, create a power of attorney of account, and start trying to collect the assets and put it in there, or, manage the assets how it should be.
Mhm. Um, if a bank won't accept a general power of attorney, how do you plan around that?
Yeah, so that sometimes happens. If a bank is like, no, they'll tell you why the power of attorney is rejected. So if it's something that you need an attorney to kind of look at, maybe the dates are off, or maybe it says that it's supposed to, expire once they become incapacitated, because that's happened. It kind of just depends on the language. It kind of depends on what the bank wants. But if the bank is not accepting it at all, then you might be heading to guardianship court, because that's what we've had to do before when a bank has not accepted the power of attorney of the state for various reasons. And it's like, okay, well, this one's apparently not valid for this reason. So now we have to go to guardianship court.
Mhm. If there are two legal guardians, I'm assuming there can't be two court-appointed legal guardians, but maybe there can. You can tell me. Like the parents of a disabled adult child, and they disagree on residential placement. How does the court decide which person prevails?
Yeah, so there can be co-guardians. So you can have co-guardian of the person. So mom and dad can be co-guardian of the person for, the child. If they don't agree, essentially what they would do is they would petition the court, and generally ask the court, or go to court. And, if it's just mom and dad and they don't have an attorney, they would just go to court. They can fill out a little paperwork, and you just let the court know, like, this is what's going on. The court in that situation may do one of two things. They may appoint a guardian ad litem to go out, see what's going on, and determine what's the best interest for that person, or they may appoint what's called the case manager, a case manager who essentially does case management, but for like developmental disabilities, and kind of make a recommendation to the court then. And generally, whatever they recommend, the court is more than likely going to do.
Okay. How is a power of attorney verified for fraud? So if you suspect that someone who claims they have power of attorney doesn't actually, how do you verify that?
So it's generally notarized. So it's notarized by a notary. And that if that notary is fraud, if it's all fraud, you know, it kind of just depends on how much we're going into it. Because sometimes we've had a case, I think like one case where, we had to go, and it was like I don't know, like they had to do like some forensics on the document, and it was like the person had doctored up the PDF, and it was like, oh no, this was doctored. So it just kind of depends on how much you want to fight it. Generally, if somebody does doctor up a power of attorney and you kind of bring it to guardianship court and it's questionable, usually people are willing to settle at that point. But if it does go a little bit deeper, yeah, I mean, you can have forensics on the document, to see whether or not it's real or if they doctored it.
Mhm. And then someone just comments that sometimes banks want their own forms to be used and not a general power of attorney. So that might be something where the bank wants you to fill out their own form, it looks like.
Yeah, so that's why a lot of times, like, again, my suggestion is if you have a power of attorney for property, give it to your financial institutions, because they'll let you know. They'll be like, well, thanks for giving this to us, but we prefer you to fill this out. So, they'll let you know. So just to kind of be proactive, because again, if the financial institution, I mean, we can make demand letters, we can do all of this stuff, but in the end of the day, if the financial institution is like, no, we might have to go to guardianship court.
Okay, great. Well, that is all the questions that were turned in. Thank you so much for your time this evening and for sharing all of this with us. And again, just a reminder to everyone, I will make sure that everyone gets the slides and a link to the recording once that is posted and we're ready with that. So thank you to all our participants. And thank you very much, Christina, for your time tonight.
Yeah, thank you guys. All
Thank
right.
you. Have a great evening.
You too. Bye.
Bye-bye.